Welcome all. Today we are going to discuss the topic Introduction to Arbitration. This whole presentation is divided into 8 parts, starting with learning objectives, followed by learning outcomes. There's a short story on arbitration, about how an arbitrator gives an arbitral award, what is arbitration, the statute governing arbitration in India, that is Arbitration Concession Act 1996, its commencement and application, the difference between domestic and international commercial arbitration, and finally the conclusion. Starting with the first, learning objectives. The first objective is to equip the audience with the knowledge and the concept of arbitration. The second is to make the audience compare arbitration with other area forums like mediation, conciliation, negotiation, so on and so forth. Third, to make audience analyze the role of an arbitrator in the process of arbitration. At what rule he has to follow, and under which rule he is bound. Fourth, to acquaint the audience with the understanding of the application of principle of natural justice. So principle of natural justice governs arbitration primarily. So therefore we need to understand that how this principle is applied in arbitration. And finally, to enable the audience appreciate the suitability of cases for arbitration, because every case is not meant for arbitration. Therefore, it is important to identify those cases which are suitable for arbitration. Learning outcomes. At the end of this presentation, the learner and the audience would be able to understand the basic concept of arbitration, what is arbitration about. They would have the attitude to work for amicable solutions for the parties and follow principle of natural justice. Thirdly, they will be equipped with the skill to identify the cases suitable for arbitration. And also they will be able to distinguish between domestic arbitration and international commercial arbitration. And finally, the learner would be able to appreciate and respect the arbitral award given by the arbitrator or arbitral tribunal. Now, as we have already discussed, the different forms of quantitative dispute resolution. So there is negotiation, mediation. In negotiation, we have seen that there are only two parties involved, the parties of the dispute. In mediation, apart from the two parties of the dispute, there is a third neutral party who assists the parties to reach an amicable solution. In conciliation becomes more, it is basically a more structured mediation, where the settlement in the conciliation process is binding and it is deemed to be an arbitral award under Arbitration Concession Act 1996. Fourthly is arbitration. So now we have reached to arbitration. Other forums are also available like Lok Adalat and judicial settlement. So today we have to discuss what is arbitration. Now, in order to understand this, there is a story. The story है वो है King Solomon के ऊपर. So once upon a time there were two women and उन दोनों के पास एक बच्चा था. So the question was, who is the mother of that child? तो जो बच्चा है उसकी माँ कौन है, तो इसलिए उनको dispute था उनके बीच में. So they chose to come to this king, that is King Solomon. तो King Solomon के पास आते हैं और उनसे पूछते हैं कि हम इसमें क्या करा जाए. तो जब King Solomon उनके पास King Solomon के पास जब आते हैं, तो King Solomon बोलता है कि आप एक काम करिए. वो तलवार मंगाता है और बोलता है मैं इसके 2 टुकड़े कर दूंगा, जिससे कि एक टुकड़ा आपको मिलेगा, दूसरा टुकड़ा उस बच्चे का दूसरी वुमेन को मिलेगा. इसमें पहला सवाल ये आता है, तो वाई King Solomon? King Solomon ही क्यों? Now, though this case reflects that the women sought to approach a third party whom they consider to be wise, trusted and independent entity. तो उन्हें लगा कि जो King Solomon है वो अनबायस्ड रहेगा क्योंकि उनका राजा है, उसको पास वो ट्रस्ट कर सकते हैं. He is having that and he is independent entity. And it may also be possible that at that point of time it was the only possible way of resolving dispute, क्योंकि उस वक्त कोर्ट्स नहीं थे, लेकिन हाँ ज्यूरी था, लेकिन फिर भी उन्होंने बोला कि हम सिर्फ King Solomon के पास जाएं. So instead of going to the jury या कोई और जज के पास जाना के बजाय उन्होंने क्या करा कि King Solomon के पास गए. Now this choice of going to King Solomon makes this case a case of arbitration, क्योंकि अगर वो कोर्ट के पास चले जाते तो लिटिगेशन हो जाता. अब आर्बिट्रेशन में क्या होता है, there is always the one has to have mutual agreement. अगर mutual agreement नहीं होगा parties के बीच में, they cannot go for arbitration. तो उसके सबसे important है there has to be an agreement which reflects the mutual agreement of both the parties. अब जब किंग ने बोला कि इसके 2 टुकड़े कर दिए जाएं, so there were few suggestions given by the parties. The first, the woman who was the real mother, जो औरत जो रियल मदर थी, उन्होंने बोला कि मेरे बच्चे को छोड़ दीजिए और जो ये दूसरी लेडी हैं उनको दे दीजिए. बट जो पहली वुमन थी, जो पहली लेडी थी, जिनका बच्चा नहीं था, उन्होंने बोला नहीं साहब, एक काम करिए, इसको 2 हिस्सों में आप बांट दीजिए, एक हिस्सा मैं रख लूंगी और एक हिस्सा ये रख लेंगे. नाउ आफ्टर लिसनिंग टू द पार्टीज, जब किंग ने दोनों को सुन लिया, किंग सोलोमन मॉडिफाइड द ऑर्डर एंड रेफ्रेन फ्रॉम स्प्लिटिंग द बॉय इनटू 2. अब क्या किया उन्होंने? नाउ ही वाज हैविंग 4 ऑप्शंस. नाउ किंग सोलोमन इज हैविंग 4 ऑप्शंस. उनमें से पहला ऑप्शन ये है कि जो पहली वुमन है उनकी बात मानी जाए और बच्चे को 2 टुकड़ों में बांट दिया जाए, या दूसरी लेडी की बात में मानी जाए और जो बच्चा है उसको पहली लेडी को दे दिया जाए. थर्ड ऑप्शन ये है कि किसी की भी बात ना मानी जाए, ना लेडी 1 की ना लेडी 2 की, और जो बच्चा है वो लेडी 2 को दे दिया जाए, जो उनके रियल मदर है. और फोर्थ है कि आप दोनों की बात नहीं मानते हैं फिर से, लेकिन जो बच्चा है वो किसी थर्ड पार्टी को दे देते हैं. सो इफ यू सी दिस स्टोरी, यू विल फाइंड दैट पहले जो लेडीज आई थी उनकी पूरी बात सुनी गई है. जस्ट इन केस ऑफ प्रिंसिपल ऑफ नेचुरल जस्टिस आप देखते हैं दैट बोथ द पार्टी शुड बी हर्ड. तो यहाँ पे दोनों पार्टी की बातें सुनी गई हैं, उनसे सजेशंस लिए गए हैं और किंग ने अपने खुद के ऑप्शंस भी दिए हैं. नाउ इफ यू सी दिस क्वेश्चंस, these reveal that the parties here have no say in the elimination of possible outcomes. वो अपने ऑप्शंस दे सकते हैं. इन केस ऑफ मीडिएशन में आपने देखा था that in mediation these are party driven solutions. पार्टी ही सॉल्यूशन देती हैं, वही सेटलमेंट करते हैं. बट यहाँ पे पार्टीज सॉल्यूशन तो दे सकती हैं, लेकिन जो सेटलमेंट है, जो अवार्ड है इसमें, वो आर्बिट्रेटर डिसाइड करता है. So parties may prefer their own possible outcomes, but the arbiter is not bound to follow the party's suggested outcomes or options. So in this above example of King Solomon, it is very clear that it was a strategy of the mother, the real mother, to say that the baby does not belong to her, so that the life of the child is saved. तो चाहती कि मेरा बच्चा बच जाए बस. Now here one more thing is very important, that whatever decision the arbiter has to take, it has to be a reasoned decision, a prudent decision. So as you know, in principle of natural justice, there has to be, both parties should be heard. There has to be an unbiased party, that is, no one should be judged in his own cause. And third, there has to be a reasoned decision. तो यहाँ पे जब किंग सोलोमन के पास आए, he was an independent entity, unbiased to both the parties. That means he was not judged in his own cause. Second, both the parties were heard. Third, there is a reasoned decision. There is a prudent decision. So now what the king did, the arbitrator, now as you know that the arbitrator has a discretion to reject some of the possible outcomes or all of the possible outcomes given by the parties. तो उन्होंने वही किया. उन्होंने जो पहली लेडी है उनकी बात को भी नहीं माना, दूसरी लेडी की बात भी नहीं मानी. उन्होंने दोनों की लेडी की बात नहीं मान के बच्चा जो रियल मदर का था उसको उनकी रियल मदर को दे दिया. Now therefore, if you see here, the King Solomon has applied principle of natural justice. He was neutral to both the parties. He calmly heard both the parties and he made a prudent decision, which are the hallmarks of principle of natural justice. So what we identify in this story, it is for this reason that no person who stands to gain or profit by the victory of one party over the other should be chosen to be an arbitrator. So he has to always be an unbiased and independent person. And also we have seen that there are principles of flexibility, fairness, swift outcome, principle of natural justice. Now these are all the components of alternative dispute resolution, where you see flexibility. That is, though we have a procedure under Arbitration Concession Act only, however, that procedure is time bound. So which makes it an alternative dispute resolution. And principle of natural justice is the major component of arbitration jurisprudence. And all these are hallmarks of arbitration. So arbitration क्या होता है? it is a mechanism. Now, when we talk about mechanism, it is an ADR mechanism. ये एक alternative dispute resolution mechanism है, in which two parties approach a mutually appointed third party. Now, this third party has to be neutral to resolve the emergent dispute between the parties, between these two parties, by following principle of natural justice, and the decision is binding on both the parties, which is called the award. So it is a simple definition of arbitration. Now, we have this act in India that is called Arbitration and Conciliation Act 1996, and short it is called 1996 Act. ये Arbitration Concession Act 1996 है, इसमें सब्सटेंटिव लॉ भी है जो बताता है कि आर्बिट्रेशन में कौन कौन से कंपोनेंट्स हैं और क्या रूल है, क्या लॉ है, और साथ में प्रोसीजरल लॉ भी यही है. That means it includes both substantive law and the procedural law in the domain of arbitration and conciliation. तो अभी हम फिलहाल arbitration ही पढ़ रहे हैं. And this whole statute is divided into 4 parts. जो पहला part है वो बताता है what is domestic arbitration, what is arbitration. Part 2 is enforcement of certain foreign awards. Part 3 is conciliation, and part 4 is supplementary provisions. So this whole statute is divided into 4 parts. Now, the commencement of 1996 Act. Now, if you see the Bare Act, the date of enactment is given as 16th of August 1996. But now this is the date when the president gave the assent. तो इसलिए डेट लिखी गई है. But this act is applicable from 25th January 1996. अब ऐसा क्यों है? The first reason is it is the continuation of Arbitration and Conciliation Act Ordinance, which was passed on 25th of January 1996. और एक केस है फ्यूल्स डे लॉसन लिमिटेड वर्सेस जिंदल एक्सपोर्ट्स लिमिटेड. उसमें ये बोला गया है कि क्योंकि ये कंटिन्यूएशन है ऑर्डिनेंस का, तो इसीलिए इसकी इफेक्टिव डेट ऑफ कमेंसमेंट होगी 25th January 1996. This was the first reason. The second reason is, which is given under the statute only, that section 86 1996 बोलता है repeal of ordinance 1996, जो ऑर्डिनेंस आया था, arbitration ऑर्डिनेंस आया था, and saving. उन्होंने बोला कि उस ऑर्डिनेंस को हटा दिया गया है इस एक्ट के थ्रू, लेकिन उसके इफेक्ट को सेव कर दिया गया है. That means if it was applicable from 20th January 1996, this act will also be applicable from 25th January 1996. तो ये second reason था. Third reason है under section 85 subsection 2 clause A, वहां पे ये बोला गया है that notwithstanding the repeal of Arbitration Act 1940, before the coming of this 1996 Act, हमारे पास था Arbitration Act 1940, which was only dealing in arbitration. अभी तो हमारे पास Conciliation Act भी है इसी के अंदर, लेकिन पहले सिर्फ Arbitration Act 1940 था. Now technically, if you see, commencement date है 16th of August 1996. तो इसका मतलब है 20th August 1996 से पहले जितने भी केस हैं 1940 एक्ट से के तहत होने चाहिए थे. But 85(2)(a बोलता है that the provisions of 1940 Act shall continue till 25th January 1996, which again gives a clarity that 25th January के बाद से आपको 1996 एक्ट ही लगाना है. तो कोई भी केस अगर इस 25th जनवरी और अगस्त 16 के बीच में आया है और अभी पेंडिंग है, तो उसमें 1996 एक्ट लगेगा. एंड ऑल्सो अंडर सेक्शन 21, अभी हमने बोला कि अगर 25th जनवरी 1996 और 16 अगस्त 1996 के बीच में कोई केस आया है तो हमें 1996 एक्ट को लगाना है. तो एक सेक्शन 21 दिया गया है that it is at the discretion of the parties that they can either go for 1940 Act or 1996 Act if the date of that case falls between 25th January 1996 to 16th of August 1996. तो एक डिस्क्रिप्शन भी दिया है कि अगर आपको नहीं करना है इस एक्ट के थ्रू तो आप उसको भी आप खुद से डिसाइड कर सकते हैं. Now there are two landmark cases. The first one is Shetty's Construction Company Private Limited versus Konkan Railway Construction. Now, as per this case, they said that the provisions of 1940 Act will apply to the arbitral proceedings commenced before 25th January 1996. उन्होंने बोला इसका जो retrospective effect है वो नहीं होगा। तो कोई भी एक्ट अगर 20 जनवरी 1996 से पहले आया है तो उसमें सिर्फ 1940 एक्ट लगेगा। Then there's another case, उन्होंने बोला Thyssen Steel Union GmbH versus Steel Authority of India. Now this GmbH stands for a German phrase जिसका मतलब होता है limited liability company. So a company with limited liability is called GmbH. It is the abbreviation of a German phrase. उस केस में बोला गया है in cases where arbitral proceedings had commenced before coming into force of 1996 and are pending, it is open to the parties that they can apply 1996. तो अभी भी पेंडिंग ही है तो आप एक काम कर सकते हैं 1996 को with mutual agreement लगा सकते हैं. Now this was all about commencement. So the date 16th August 1996, which is the date given in the Bear Act, is not the commencement date of this act. However, 20th January 1996 will be taken as the date of commencement of this 1996 act. Now, application of this act, ये कहाँ पे apply होती है? Now, if you would have seen, काफी लोग बोलते हैं that commercial dispute है, तो आप एक काम करिए इसमें arbitration लगाइए. But that is not the case. It is not a rule that only for commercial matters arbitration लगता है. हाँ, ये जरूर है कि arbitration ज्यादातर commercial matters में लगता है, but it is not the rule. The rule says it has to be a civil dispute, either commercial or non-commercial. But अगर वो civil dispute है, and if there is an agreement, तो agreement बहुत जरूरी है arbitration करने के लिए, because आपने King Solomon की story में भी देखा था, उन दोनों औरतों ने ये सोचा कि हमें King Solomon के पास जाना है. If they would have not agreed, if there would have been no mutual consent, तो आप arbitration नहीं कर सकते. So the first and the foremost requirement to go for arbitration is that there has to be an arbitration agreement. That is a mutual agreement between the parties. Now, so reference to arbitration and arbitrability depends upon the existence of an arbitration agreement and not on the question whether it is a civil dispute or a commercial dispute. And there is also a case, H. Srinivas Pai versus H.V. Pai, that there can be an arbitration agreement in non-commercial civil disputes. So they have categorically mentioned it, that even if the dispute is not commercial, it is civil in nature that can be tried in arbitration. Now, what is arbitration? हमने definition पढ़ी है that it is an ADR mechanism in which two parties approach a third neutral party who, by following principle of natural justice, gives a decision which is called arbitral award. Now, under 1996, arbitration clearly defined नहीं किया गया. If you read section 2, subsection 1, clause A, वहाँ पे बोला गया है arbitration also includes arbitration by permanent arbitral institutions. मतलब वहाँ बोला है कि अगर ad hoc arbitration भी हो सकता है और permanent arbitration भी हो सकता है. But what is arbitration has not been clearly defined. Under section 2(1)(b), वहाँ बोला गया है arbitration agreement is an agreement referred under section 7. Now, section 7 talks about the requirements for an arbitration agreement. Then we have arbitral award, which is defined under section 2(1)(c). वो बोलता है that arbitral awards includes any interim award. So even if the final award has not been passed, but there's an interim decision on that matter, that will also be deemed to be an arbitral award. And finally, section 2, subsection 1, clause D talks about arbitral tribunal, जो बोलता है either there may be a single arbitrator or a panel of arbitrators, which will be called as arbitral tribunal. So these are certain terms which are required to know what is arbitration. Now, domestic arbitration. Now again, domestic arbitration is nowhere defined, but you can find or you can infer the definition of domestic arbitration from certain provisions which provide for domestic arbitration. So not expressly defined under 1996 Act, but an arbitration which is held in India, जो इंडिया में करा गया है, and an outcome of which is a domestic award. अब मैं आपको बताया था that we have part 1, part 2, part 3, part 4. Part 1 talks about arbitration. Part 2 talks about enforcement of certain foreign awards. Part 3 talks about conciliation, and part 4 talks about supplementary provisions. तो जो भी arbitration पार्ट 1 के तहत किया गया है, that and इसका अवार्ड डोमेस्टिक अवार्ड है, will be called as domestic arbitration. तो जो इंडिया में किया गया है पार्ट 1 के तहत किया गया है, that will be called as, and इसका अवार्ड भी इंडिया में आया है, and which is as per the part 1 will be called as domestic arbitration. Now if you read section 2 subsection 2, वो ये बोलते हैं that part 1 applies to the arbitration which is done in India. So if the place of arbitration is in India, तो हम उसको बोलेंगे domestic arbitration as per section 2 subsection 2. Now 2 subsection 2 has to be read with 2 subsection 7, which says that the award as per part 1 is called a domestic award. So therefore if you see this definition, it says section 2 subsection 2 बोलता है that the place has to be India, the award has to be in India. So then it will be called as domestic award. And also under section 28(1) A, उसमें बोला गया है that the rules, there have been a bifurcation. उसमें गया है, बोला गया domestic arbitration अगर होगा तो rules जो apply होंगे वो इंडिया के substantive laws के rules होंगे, और अगर वो international commercial arbitration है तो उसका different procedure दिया है. So one can again infer that there has been a bifurcation in terms of the application of the act over domestic arbitration and international commercial arbitration. Now, what is international commercial arbitration? वो होता क्या है? It has been defined under section 2, subsection 1, clause F. वहां पे ये बोला गया है, any arbitration, even if it is not commercial, but where it has to be commercial though, any arbitration which is in which one of the party is other than India. So at least one party use किया गया, that means even both the parties can be outside India. तो अगर दोनों बाहर की पार्टी भी हैं तब भी उसके हम बोलेंगे इंटरनेशनल कमर्शियल आर्बिट्रेशन. बट अगर दोनों पार्टीज इंडिया की हैं then will become, then we'll have to see where the place of arbitration, जिसके लिए हम बाद में डिसाइड, बाद में हम देखेंगे, उसको डिस्कस करेंगे. बट द डेफिनेशन क्लियरली सेज दैट व्हेन वन ऑफ द पार्टी टू आर्बिट्रेशन, जब कोई एक पार्टी जो आर्बिट्रेशन के लिए आई हुई है इज आउटसाइड इंडिया, देन दैट आर्बिट्रेशन इज कॉल्ड इंटरनेशनल कमर्शियल आर्बिट्रेशन. तो पहला कंडीशन है इंडिविजुअल, तो या तो कोई इंडिविजुअल बाहर का हो, बॉडी कॉर्पोरेट बाहर का हो, association of persons बाहर का हो, या गवर्नमेंट बाहर की हो. In all these 4 cases, and if these belong to a different nation, then this will called as international commercial arbitration. पहले इस definition में company word use किया गया था, which has been omitted by Arbitration and Commercial and Conciliation Amendment Act 2016 with retrospective effect from 23/10/2015. तो अब company word use नहीं किया जाता है. So now here we conclude today's discussion. So what is arbitration? It is a legal process, a technique, or a mechanism for the resolution of disputes outside the court, wherein the parties to dispute refer it to one or more person. So either it can be one arbitrator or an arbitral tribunal. The arbitrators, arbiters, or arbitral tribunal, by whose decision, now this decision is called award, they agree to bound, because this is binding. Unlike mediation, mediation is non-binding per se, but it can be made binding by the backing of the court. But here it is per se binding. Arbitration is per se binding. There can be no arbitration without an arbitration agreement. तो अगर आपको arbitration के लिए जाना है, there has to be pre-mutual consent. तो आप लोगों को पहले लिखना पड़ेगा agreement कि that in case of any dispute, the parties will approach the arbitrator. But yes, again, arbitrator को चूज करने का मौका डिस्क्रिप्शन पार्टीज के ऊपर होता है, और लेकिन कोर्ट में, so this is the difference between court and arbitration. In litigation, जो जज है उसको आप डिसाइड नहीं कर सकते कि कौन जज बनेगा आपके केस में. But in case of arbitration, who will be the arbitrator is chosen by the parties. So this makes it an alternative form of dispute resolution, because ADR is having peculiar characteristics which are far better and advantageous than the litigation system. So an arbitrator can consider but is not bound to follow the options given by the parties. तो जो arbitration process में जो भी parties ने बोला है, because as you know that arbitrator has to follow principle of natural justice, so he listens both the parties, but he's not bound to follow the options given by the parties. If he likes the award, if he likes the options and he feels it is in consonance with principle of natural justice, he will make that award. Otherwise, he will have his own award. An arbitrator is bound by principle of natural justice. It is very clear from the story. Arbitral award reached in an arbitral process is binding upon the parties. तो यहाँ पे एक बार award declare हो चुका है. It is deemed to be a decree of civil court. And in India, it is governed by Arbitration and Conciliation Act 1996. So this was all about arbitration. Thank you.